All rise. Ladies and gentlemen, the Supreme Court of Alabama. Hear ye, hear ye. The Supreme Court of Alabama is now in session. God save the state of Alabama and these United States, and bless this honorable court.
Good morning, everybody. Have a seat, please. Just as a point of personal privilege, it's so much fun to see lawyers that were in front of me as a trial judge, now in front of me, Mr. Butler. It's kind of a fun thing. It's been, 20 years, right? Yeah. So thank you all very much for being here today. Is the appellant ready? Okay, and the appellee? All right, Mr. Jordan and Mr. Neiman. You ready?
Good morning, everyone. We're here this morning for oral argument in the Supreme Court case of SC 2024-0121. The parties before the court this morning are Nissan North America Incorporated and Nissan Motor Company Limited versus Alise Henderson Brundidge and Kelley Morgan as Alise's mother and next friend. Arguing for the appellants this morning will be the Honorable John Nyman. Arguing for the appellees will be the Honorable Burt Jordan.
Thank you, Madam Chief Justice, and may it please the court. As it turns out, this case is about the respect that the law accords to the work of trial judges when, in the course of presiding over jury trials, they conclude that something has gone foundationally wrong with one of these juries, and that as a result, in their judgment, justice requires a new trial. This case also is about the respect the law should accord to the meticulous work done by this particular trial judge. When my clients filed their motions for post-judgment relief, Judge Pipes took the highly unusual step of asking the parties to consent to additional time beyond the normal 90 days so that he could adequately consider and address issues that he would later describe as extremely concerning to him. And despite what are now repeated suggestions the other side has made on appeal, both sides consented to that additional time in a timely way, on the record, and in a motion that was filed not by my clients, but in fact the plaintiff. The result of all that was an unusually thoughtful order in which Judge Pipes explained that in his judgment, something had gone foundationally wrong with this jury, and that justice in his mind did require a new trial. And although I'm here representing the appellants in this case, I'm also here to agree with almost everything Judge Pipes had to say about that. He was right when he concluded that the failure of these two jurors to truthfully answer questions during voir dire resulted in probable prejudice to my clients. He was right when he concluded, and I'm quoting from the order now, if given a free hand, the court would grant the motion for new trial. The only reason why he didn't grant the motion for new trial was that he thought he didn't have that free hand. He read two of this court's cases as precluding him from finding these non-disclosures material as a matter of law. And it is on that conclusion of law that we have our sole, very respectful disagreement with this esteemed judge on this issue. I'm prepared to address the other issues in this appeal, JML, remitter, but I would be remiss if I left the courtroom today without addressing two specific points about this new trial issue. First, why Judge Pipes was right, and certainly acted within his discretion when he found that these non-disclosures were material. And second, why he was mistaken when he read this court's cases as prohibiting him from ordering the new trial that he otherwise thought justice required. So on the question,
So just to be clear, it's your position that his factual findings were correct.
that's right, his application of the Freeman factors to the facts of this case were correct. His conclusion from the application of those factors was that a new trial was required. That conclusion is correct. That's something this court should review only for an exceedance of his discretion. What we're asking the
Your
court to do,
disagreement is you think he's wrong on the law about what materiality is.
I think that we think that he's misreading the two precedents, or two cases, I should say, that he cited, Hood and Jimmy Day, and that as a result, he's reading those cases as tying his hands on the materiality question far more than they in fact do.
Aren't there similarities between Hood and this case on materiality?
So I think the answer to that question, Justice Bryan, lies in why he was correct about these non-disclosures being material. There are facial similarities between what was going on in Hood and what the non-disclosures we had in this case. But the facts of Hood, and in particular the identity of the parties in Hood, was dramatically different. But let me start first by addressing the precedential significance of the Hood opinions. Hood did not generate a majority opinion at all, and certainly didn't generate a majority opinion on the materiality issue. The materiality discussion that Judge Pipes referenced was in a four-justice plurality. There was also a four-justice opinions authored by Justice Maine, styled as a dissent, that went the other way on materiality, and Justice Shaw's concurrence in the result provided the fifth vote necessary for the judgment of reversal in that case, but did not address materiality at all. So certainly the plurality decision in Hood did not control Judge Pipes's analysis here. It also bears noting that really, if the court asked me to choose which of those four justice opinions, which approach I think should become a majority opinion, I would suggest Justice Maine's, but the court doesn't have to choose, and I don't think the court has to select between those two opinions. That's because the through line between the four justice plurality and Justice Shaw's concurrence in the result is that there was a lot more going on in Hood than just materiality. The plurality said that it would be hard-pressed to find that any of the Freeman factors were present in that case. Justice Shaw likewise premised his decision in no small part upon the fact that the question asked of the jurors in that case was inherently ambiguous, fundamentally so. And we just don't have that issue here in this case, where Judge Pipes found that the question posed by plaintiff's counsel here to the jurors was unambiguous. So in terms of the precedential significance of Hood as to the materiality question, Justice Bryan, Hood just simply doesn't provide that backdrop. Now, all that said, even more critically than that, Hood was different on the facts. Hood was distinguishable on those facts because the parties were different. The defendant in Hood was not a corporate defendant. The defendant in Hood was a state official, and the party, as Justice Shaw noted in his concurrence in the result, that was seeking the new trial in that case was the plaintiff, after the plaintiff had prevailed at the trial below. Those facts make all the difference in the world, and that's all tied up in what I want to explain about why why Judge Pipes was correct to find these non-disclosures material on the facts of this rather different case. Here's why they were material here. The number one reason, or the number one hurdle that companies like my clients face when they walk into a jury trial, and especially a products trial, is the narrative, which we obviously think is unfair and untrue, that corporations simply don't care about people, that they care only about money, that they elevate concern about their economic bottom line over all other concerns. That means that a priority for corporate defendants in these trials is making sure that no individual walks into a jury room with life experience that will just quite naturally predispose themselves towards that anti-corporate narrative. That's why it was such a massive problem that two jurors made their way onto this panel with this undisclosed experience with corporations going after them personally in these collections proceedings. Now, the plaintiff in this case dismisses the significance of those collections proceedings, but the fact that they are collections proceedings is the very thing that makes them material on the facts of this case, really acutely so. These collections proceedings are matters in which a business is trying to garnish wages of an individual, where they're looking to evict them from their homes, where they're potentially taking their property. At a human level, that's just a life-altering event. When you're a defendant, an individual defendant in one of these collections proceedings, the plaintiff, the business, the company, the corporation, isn't trying to get insurance proceeds out of some insurance policy you have. They're going after you personally. And if someone on the jury has experience in which they've perceived that some uncaring corporation has used the courts to extract every possible penny they can from that individual, then they're just naturally going to be much more susceptible to a thematic suggestion at a trial like this one that as jurors, they should try to extract every possible penny they can as well from the corporate defendant in that case, no matter what the law or the evidence says. That theme, the anti-corporate theme, was threaded into the plaintiff's case here. To give you just one example, page 1215 of the transcript, the plaintiffs are cross-examining one of our experts, Karen Bolovich. Counsel begins by asking her about her education and saying, part of what you learned was how to make and keep money at corporations. And more generally, the entire theme of plaintiff's case was that this corporate defendant was well aware of dangers associated with airbags, but just didn't do numerous things that the plaintiff said this corporation should have done. These dynamics are why during voir dire, Nissan went out of its way to tell the jurors that they were going to ask them to treat this corporation on equal footing with this individual. And that's why it mattered so much to this corporate defendant that these two jurors had this history of being pursued personally by corporations.
So let me interrupt. I'm going to go back to the basics. Okay, so the materiality factor in the Freeman case, it's got two prongs to it, right?
Well, there's some debate in the case law about that. There's
subjective and objective,
yes.
Right?
Yes.
And so Judge Pipes very clearly found subjective materiality, right?
Correct.
And by that, as I understand it, he meant that the trial counsel would have struck those jurors had they been told the truth.
Correct. He had an affidavit from my colleague, Warren Butler. Mr. Butler said he would have struck these jurors. Judge Pipes expressly found in his post-judgment order that he believed Mr. Butler on that point.
So then there's a second prong to materiality. It's objective materiality, right?
Well, let me say yes, but qualify my answer just slightly, Justice Cook. The reason why I qualify the answer is that there is some debate in the case law about whether the test is conjunctive or subjunctive. In other words, is it either or? If you show subjective materiality, perhaps you don't have to show objective materiality. Justice Shaw has written to this in a dissent he wrote from a no opinion affirmance in a case called Dog and Court versus Smith.
What did he say? And or.
Well, so he cited precedents, including Ex parte Du Bois from this case, which use the word or between the subjective test and the objective test. The plurality in Hood was largely concerned really not about applying the materiality standard to the facts, although it did so. Its principal analysis was to disagree, not necessarily with Justice Shaw directly, but with the notion that it's subjunctive. And instead,
what is the case that Justice Shaw has where he used an or?
it's called Ex parte Deboyne, Deboyne. That said,
So let's get back to my test. So it's the objective is the second prong.
yes, and to be clear,
It's the second prong.
yes.
And Judge Pipes said that he found objective materiality too, but then said he didn't think the law allowed him to do that. Am I correctly saying what he found?
That's exactly what he said. Yes, Your Honor.
He never said how he found objective materiality, right? He didn't say what the test was for objective materiality.
Well, I mean, he said these were objectively material. He noted that it is entirely understandable that both sides would want this information. So I think that what he is saying is that any lawyer who walked into that particular case would want to have this particular.
But that's different from saying, as I understand the test for objective materiality, is what a reasonable lawyer in that circumstance would have struck that juror had they been told the truth.
Well, yeah, I don't think the law makes it entirely clear how it works. Again, because it's not even clear whether we're talking about a conjunctive or a subjunctive test. But that's fair enough. But I think Judge
Pipes doesn't say what he's using, what standards he's using. He didn't say that a reasonable lawyer in those circumstances would have struck that juror.
Well, no, he says it's understandable that both sides would want that information, and that conclusion, first of all, should be reviewed only for abuse of discretion, but second of all, was eminently correct for all the reasons.
I'm running out of time to ask where I was kind of building up to the question I want, which is, what if we agreed with you that Judge Pipes's factual findings were in your favor, but the law was different? Shouldn't we remand it to him to apply with the correct law rather than deciding it ourselves?
That's certainly one option that would be available to the court. I don't think that really ought to be the first choice. The reason why is that Judge Pipes took this time to write this meticulous order in part to make it absolutely clear to both the parties and the court what his reasoning was. His order makes it absolutely clear that he believes that a new trial was warranted on the application of the Freeman factors. If this court concludes that Hood and Jimmy Day did not constrain him from reaching that conclusion, then I think the right result is to say he was right to order a new trial and to remand for a new trial rather than his application of the Freeman factors all over again, which he's already done, and we know what the result of that.
But plaintiff counsel haven't had the chance to argue that his factual findings are arbitrary and capricious and that he's beyond his discretion in doing that because he found in their favor. It's like penalizing plaintiff's counsel when they didn't have a chance to make the argument. Don't you think?
Well, plaintiff's counsel certainly has the opportunity in this court to argue that those findings were an abuse of discretion, and they haven't shown as much in their brief. I think in order to obtain an affirmance here and no new trial, they would have needed to show in their brief here.
You think they have to argue that the judge you found in their favor abused his discretion?
Well, first of all, Justice Cook, let me make it clear. Your suggestion that one possible outcome here is a remand for Judge Pipes to apply Freeman free of the constraints that he believed were there. That's certainly one possibility. But once we pressed the issue in this court and we said Judge Pipes was right in terms of his application of the Freeman factors, and the only problem here was his application or understanding, his reading of these two precedents, it was incumbent on the plaintiffs to show in this court that Judge Pipes's application of those Freeman factors was incorrect. And because they didn't do that, I think that if the court doesn't choose to remand and let Judge Pipes review this matter or apply the factors again, the better course of action really is to say that in light of Judge Pipes' ruling here, the right result was to order a new trial.
Mr. Nyman, you're running out of time. I just had one quick question. Does it matter when the parties discovered that the members of the jury had been untruthful? Does the timing of that matter? That they find out? Do they know before, after the question was answered, during trial? Do they have any duty to check and make sure that the jurors accurately answered the question and only discover it after the trial and then raise it because they lost the case?
Well, Justice Sellers, I don't think there's any suggestion in this case that anyone knew about the true nature of these two jurors' litigation history at the time that the jury was struck, or at the time that the trial, the opening statements began and the trial proceeded. So we're not operating in that universe. With respect to when the Nissan defendants were required to raise that issue, that the matters of timing, procedure in terms of how these issues get resolved are also within the discretion of the trial judge. Judge Pipes acted well within that discretion here, in part because this court's precedents make clear that a motion for new trial is an appropriate time to raise these issues, but also because, especially with respect to one of these jurors, FW, her name wasn't even available to the parties until the morning of trial.
Thank you.
Thank you, Mr. Nutman.
Thank you.
Mr. McCall, will you add the extra time to Alise? Okay. Mr. Gurdon?
Chief Justice Stewart, may it please the court, I'm Albert Jordan, speaking for Alise Henderson Brundidge. I think I should start right by picking up on your questions, Your Honor. First of all, there is plainly precedent to support the conclusion that the non-disclosure by these two jurors of these small collections matters is immaterial. And you don't really have to parse through Hood to get there. I think you can look at the Marinelli case from '93. I think you can look at the Boudreaux case from 2012. And they support the conclusion, the legal conclusion, that these non-disclosures are immaterial. They are small claims, and they don't involve personal injury. And if you look at the precise details of the record about these cases, you see that what they reflect is a couple of consent judgments, one dismissal, some lack of temporality, some defaults, which are not ironclad, as we know, and then they're unlawful detainers. And some of these, again, are quite remote. So I do think the law certainly would allow for the conclusion, as a matter of discretion, that no new trial is warranted. Now, with respect to the question of what you do if you think Judge Pipes might have concluded that a new trial was warranted because of the way he sorted through this, we think that typical rules of appellate review call for a different approach than a remand. We think that of course it's well established that this court will affirm the trial court on any valid legal ground presented by the record, regardless of whether that was considered or even if it was rejected by the trial court. On that basis alone, the court could conclude that the denial of the motion for new trial was not improper. In addition, when looking at the information in the record, the record should be construed most favorably to the non-moving party. That comes from the case of Boudreaux versus Petway, which is familiar. So on either of those bases, this court could just say Judge Pipes reached the right conclusion. You might think you want to be deferential to his work in this, and certainly that's understandable, but you really don't affirm work, you affirm judgments. You don't affirm rationale, you affirm judgments, because you have to direct the supervision of the courts. So in another respect too, I think it's not altogether clear that Judge Pipes would have concluded that there should be a new trial. Let's be clear about exactly what he said on the subject of non-disclosure. He said the court cannot find there was probable prejudice from an objective standpoint. Nissan benchmarks its position on the trial judge saying what he would do if he had a free hand. But he does not have a free hand. He always remains subject to your supervisory power. The law does not give the judge a mere free hand. It's a turn of phrase, but it's hardly a reflection of an exercise of legal discretion. The trial court's inability to find probable prejudice controls here. So those are my comments about the motion for a new trial. I want to make a couple of other points that I think really need to be addressed. In 2018, Alise, a 15-year-old girl, suffered life-altering trauma from a Nissan airbag that should not even have deployed in a low-speed car collision, a mere fender bender. The airbag then struck her face and eyes before it finished opening. As is now conceded, and was not conceded in the trial court, the airbag itself caused her to suffer temporary total blindness and then complete permanent blindness in one eye. And she is at continuing medical and social risk of loss to the other eye. In 2023, the jury followed the instructions by the trial judge, pattern instructions not objected to, and awarded $8.5 million for the loss of the eye, the disfigurement, the pain, the emotional anguish, and the loss of enjoyment she will experience, not for just a few months, but for the next several decades of her life, including the fear and extra risk of losing to glaucoma, the eye with the remaining vision. The case concerns a lot of testimony about the flaws in the airbag system. And my learned opponent didn't speak to it, but there's several potential flaws that are identified by the experts. But I want to focus you on one particular flaw that really stands out and I think helps you grasp this tragedy. This airbag suffers from one simple defect that makes its danger unreasonable. It deploys even though the car impact speed is low for a seat-belted occupant, like Alise. The witness, Mr. William Broadhead, the expert who had been in the field since before 1980, that is the field of safety from airbags and seatbelts, said the airbag is not needed for a seatbelted passenger until the impact is 15 miles an hour. But here, the impact speed is 9.1 miles per hour. He says the alternative design is a simple switch signal in the seatbelt buckle, sends an electrical impulse. In the language of this business, this is called a dual threshold. So in the blue brief, you see a good bit of discussion about how something called the no-fire threshold is really a red herring because it's too low, it's 6.5. But that's talking about an unbelted occupant. In this case, it's about a belted occupant.
Let's go back to the the new trial question, because that's bigger concern to me here. And frankly, they're not pursuing a Daubert argument here, are they? They've not made that in the briefs. I don't see it anywhere. Did they do that at the trial level?
The argument about the belt.
Right. They didn't make a Daubert argument in their briefs, right, on appeal.
No, as a matter of fact, the best they got was to say that when Mr. Broadhead made these observations about a belted occupant, that he was speculating. And Your Honor, I would direct you to pages 640.
So because they didn't make the argument, I'm not, you agree with me it's waived, right? If you don't make it, it's waived. So their argument about Daubert would not be, that they've not made that. And
I hope they don't bring it up on reply, but you're right, Your Honor. But it's there in the blue brief, and of course, I'm here to answer your questions.
So I want to go back to sort of the build up here. You agree with me that, and the Freeman factor is materiality is the most important factor, right?
It is, and they all seem to have a bearing on it, even though they're differentiated. But it feels like unless
You're weighing, I mean, it's discretionary, you're weighing those factors.
It absolutely, and for that matter, there's a certain instinct in which you read Judge Pipes and you kind of want to say to yourself, well, if he wants a new trial, I'll let him have one, because that's his assessment of it. But he backs off that pretty plainly, and that's what I'm saying is that his comment about a free hand is really a sort of a half-hearted kind of way of saying that he thinks that he won't bring himself to say there needs to be a new trial. In fact, that's what he says point blank, and that was really my point about.
But he made a factual finding of subjective materiality, right? He said, this lawyer says in an affidavit that he would have struck them, and I believe them, right? That's subjective materiality.
You're right.
And he agrees with it. On the objective materiality, do you agree with me that the standard is whether or not a reasonable counsel would have struck that juror had they known the truth?
I think that it may not be quite that open-ended. I think it may be more a matter of the degree to which this court is willing to let all the investment and the time and money of the trial be relinquished, and you have to start over again merely because the lawyer is being reasonable. To the extent it doesn't reflect the delay in asking, doesn't reflect a waiver, kind of like Justice Sellers was suggesting that these people really do know these facts long before we get to the end of the case. They could have brought this up. They say they couldn't bring it up because they didn't know FW until the day of the trial. Well, they knew all the others, the 230. In fact, they knew JB was, even though she didn't speak of the small claims that had been brought against her, but they know on day one that she hasn't told them that there's a small claim. So
you think they need to run 230 people through Alicourt one at a time? How big is their trial team? I mean, how much time do they have to do that?
I think it's pretty big, but your 230 is a lot of people. Of course, there's 30 there for the selection of the jury. But I do think that it has to do with the what's expected of the lawyers in light of the system and the fact that we let this process go on. And I think that has something to do with how you evaluate the materiality of it. Even though Mr. Butler says he would have done that,
I agree with you. I agree with you, at least I'm only one of 9, but I agree with you that subjective materiality is not enough. It's not enough that Mr. Butler says, I would have struck him, and the judge says, yeah, I believe you. I think you have to have a reasonable person test. I think that objective materiality is an additional requirement. You have to have that.
I think all I'm saying is you don't focus it solely on the lawyer. There are other features of the system that bear on what's objectively material.
Do you think there's a bright line test to say if it's small claims that you weren't truthful about, that's never going to be enough?
I beg your pardon. I think you're very close to that in reading these cases over a long period of time, both from the Hornsby era of the 93 and the Marinelli case to Justice Shaw's opinion in Boudreaux, where this discretion is upheld. These imply to the court that these kinds of small claims issues really don't justify disrupting the completion of the process, the fact that we've completed the process.
Those are cases where the court was just affirming the trial judge for his decision. They weren't saying the trial judge got it wrong when the trial judge says it's a small claims case.
True. But what I'm saying to you is the record in this case supports affirmance, notwithstanding Judge Pipes' separate factual conclusions. That is the well-established standard of review. And furthermore, the facts that were before Judge Pipes are due to be construed in favor of upholding the judgment if possible.
Do you think that the fact that Nissan did not strike juror 13, who had a sister that was blind, goes against their argument of materiality with an issue with jurors who had small claim cases?
I think that the evaluation of who they chose to strike and who they didn't choose to strike is a factor, but I do think that you're really coming close to this notion that these small claims, they're property claims, and the record's ambiguous about them, and as a consequence, it's hard to come to the conclusion that we have to throw out 7 days of trial with these people. Now, with respect to, and so I'm not suggesting that you need to look at that to second guess the subjective materiality assessment. I don't think you should second guess the lawyer merely on that basis. I would.
Mr. Jordan, can I ask I'm sorry. Were you? I have a question.
Yes, sir.
Are you arguing for I just want to make sure I'm clear on this. It kind of sounds like we're headed towards some kind of bright line rule that, if it's a small claims case involving property, then it's not material, just period. Now, we all come here, none of us come here from a vacuum. So we all had careers before this. My background was in the criminal side of the law. And so is that analogous to saying, okay, well, a prosecutor can't strike a juror who has traffic tickets if it's a murder case? I mean, are we trying to create some kind of bright line rule, or should we not just leave that, not second guess the decisions or the reasoning of the lawyers in the case? I guess.
I think you have to put into a different category criminal cases because of serious criminal cases, serious crime, because imprisonment's at stake. Mm-hmm. You have to look at it differently. There's no punishment at stake at this case.
So how is that different if it's? If you have a burglary case, I mean, are we trying to limit? Are we arguing for a bright line rule? I guess is my bottom line. Are you saying that we should not? That we should say no? This was a small claims case, and this is a lawsuit over personal injuries. Therefore, it's just not material. Is that the argument where we're going, or are you still talking about something else more subjective?
The record supports the idea that it's not material, and that's consistent with your precedents. I do think that once you get to the criminal world, it's a different process. I will say a couple of things.
Well, let's forget about that. Let's just talk about this case.
Yes, sir.
Okay, are you arguing for a bright line rule that says small claims cases are just not material to a case like this? I just want to be clear on that.
I think that I would frame the rules slightly differently. I would say they're presumptively not material.
Okay.
And so one thing that is said here is this: Judge Pipes was fixed on the notion that JB was a legal secretary. I have to tell you, just be careful, because the blue brief is incorrect in saying that she's a legal secretary. If you look at the reporter's transcript on page 95, you'll see that she hasn't been a legal secretary for 22 years. So she was at one time in her life a legal secretary. To the extent that may bear on how concerned you are about the truthfulness of these people, certainly that would discount the worry that JB is someone who is being intentionally deceptive, and to the extent that bears. Now,
but counsel, if you ask a question and the question is not answered appropriately, it seems like the materiality is, did you answer the question properly or not? And we're trying to, it seems, parse that to say, well, maybe if they didn't understand it, maybe that would be one thing. But it looks like to me that the question was fairly direct and they failed to answer it. And so then we pull back and say, well, maybe that wasn't material, so we discount that. And I'm like, Justice McCool, I think, is trying to find this scale sliding. And in order for us to do this, it's helpful to have a little bit more bulk.
To help you, Justice Sellers, if you actually look at the question, the way the question's framed, it's not exactly like Judge Pipes reports it. It's a little bit more ambiguous than that. And I think I need to direct your attention to page 69 of the reporter's transcript. This is where plaintiff's counsel, Mr. Dunson, is asking questions. And the way the court reporter has formatted it, it's close to what it looks like in the McElroy case. But the word okay is between the first question, which is anyone been sued? Okay, how about does anyone own a business that's been sued? Anybody? All right. So there's no affirmative negative in there.
I've got a different quote that I've gotten from the order. It says, let's switch it around.
That's right.
Has anyone else been sued before? Anyone else sued
Correct.
before?
Correct.
And there's a response by juror 23.
Yes.
And then he says, anyone else been sued? It sounds like he's asked the question 3 times, and it seems pretty unambiguous to me.
It is unambiguous, but what he does at the point that you're reading it the second or third time is he switches to say, does anyone own a business that's been sued? So in a sense, after listening to 23 talk, he listens to 23 tell about somebody running out in front of his brother while he's driving the juror's car. And so they're focused on car wrecks, if you will, with all due respect. So I'm saying to you, Justice Cook, that it is possible to read it like Judge Pipes read it, but it is also possible, if you're going to construe the record most favorably to sustaining the judgment, there is not a negative response here. That's the difference.
Judge Pipes is making a factual finding, though, that this juror was untruthful and that the questions were clear and unambiguous. Am I supposed to disagree with his factual finding? He was there. He listened to it.
Your well-established rule on review is that you are to affirm a judgment if the record will support it, even if it's on a basis rejected by the trial judge. That's where I'm coming from.
He's made a factual finding. I can't disagree with that unless it's arbitrary and capricious.
Well, I think you've established that these kind of run-on questions have the potential to imply ambiguity. And so that's a factor in whether it's objectively material.
But isn't
And I
that-
think that's the approach. I'm sorry.
But isn't that why we leave it to the, I'm sorry, right here. But isn't that why we leave it to the trial judge to make those kinds of rulings, to make those factual findings, whether it's ambiguous or not?
Well, you certainly want to be deferential if you can, but Hood versus McElroy says you'll second guess him if you feel that there's a run-on question. I mean, even Justice Shaw, in his concurrence in the result, was concerned about the way the questions were framed up. And
Mr. Jordan,
and these people aren't perfect.
you're out of time. You can finish your statement, but we're out of time.
I think all I'd like to say in conclusion, thank you, Chief Justice Stewart, is that trials aren't perfect. Don't let the perfect be the enemy of the good. This was a good trial. It's well done. And we recommend that you affirm the judgment. Thank you.
Mr. Nyman? Mr. McCall, will you add some extra time to Mr. Nyman?
Thank you, Madam Chief Justice. I'd like to respond to a few of the questions that were asked of Mr. Jordan, and I'd like to respond to a few of the answers he gave. First, to start with the questions Justice Cook has asked both of us about the standard for objective materiality. First of all, let me be clear. This is not a hill I have to die on in terms of a choice between objective and subjective materiality here. I do read Judge Pipes' order as finding both objective and subjective materiality when he says that that this caused probable prejudice to Nissan. There's a parenthetical afterwards in which he says both objectively and subjectively. So we do have a finding, I believe, from the trial judge on that point. That raises the question: what is the standard for objective materiality? Jimmy Day. Okay, so standard for objective materiality under Jimmy Day, one of the decisions that, of course, the other side is relying on is a material fact is one which an attorney acting as a reasonably competent attorney would consider important in making the decision whether or not to excuse a prospective juror. So that's a standard that makes sense and that is completely compatible with Judge Pipes' finding here. It doesn't mean that every single attorney has to find a particular fact important, and there's no one-size-fits-all rule. But the question is whether a reasonably competent attorney would consider that important. And that's certainly the case with respect to the non-disclosures here. The other side has suggested that there ought to be a bright line rule here, or at least got very close to that in response to Justice McCool's question. There cannot be a bright line rule in these cases. Materiality always depends on context. No two trials are exactly alike, and the context here of this particular trial was dramatically different from, say, the trial in Hood, where you did not have a corporate defendant who was concerned about the anti-corporate narrative that motivated our challenge. Here, you instead had a state official as a defendant and a plaintiff who was seeking the new trial. That makes the discussion of materiality in Hood inapt for the purposes of this case, and it suggests that there can't be a bright line rule because there may well be cases in which, for whatever reason, small claims experience being with a party being sued by a corporation isn't going to matter. If a corporation is not involved in the case, for example, as was the case in Hood. Because a corporation was involved here, the materiality analysis was different. Judge Pipes's analysis was no abuse of discretion. Justice Wise asked a question about whether the fact that we didn't strike a particular juror who had a sister who had suffered from blindness undermines Judge Pipes's findings in any way. I didn't understand the other side to second guess Judge Pipes's finding of subjective materiality and his credibility determination with respect to Mr. Butler. But just to be clear, there were all sorts of reasons why we would much prefer to have that juror, a juror with that kind of experience on the panel, over a juror who had had experience being personally pursued by corporations, having her wages garnished, and the like. A juror who had a relative who had suffered from blindness might be more amenable to certain arguments we would make in terms of whether it's about liability or damages. We definitely could live with a juror like that. We cannot live with a juror who has this kind of predisposition to this anti-corporate narrative that is, at the end of the day, the number one concern for any corporation that walks into a product's liability trial.
Mr. Nyman, is it really the corporate aspect, or it's just they were asked a question and they didn't tell the truth? At what point do we address that? It seems like we're saying, well, it's material, whether they lied this much, a little white lie, that there's some gradation. I didn't tell the truth. How do we slide that on materiality, what a reasonable lawyer may or may not have done? I mean, it seems like whether it's a corporate defendant or not, somebody's asked a question, it's going to be a juror, and they don't tell the truth. I mean, do we get to that, or do we have to qualify that with all these different tests that you're talking about?
Well, the Freeman factors suppose that this is a multi-factor analysis. So there may well be a case in which one factor points so overwhelmingly towards a new trial that it really doesn't matter what the way the other factors point. So you could have, as Justice Sellers I think has suggested, a circumstance in which the evidence that the juror was not telling the truth was so compelling as to raise an inference of probable prejudice, even absent a finding of materiality. Fortunately, for my argument, I'm not in the position of having to ask you to adopt that rule in this case because we have an opinion from Judge Pipes in which he's applied all 5 of those factors and concluded that justice did require a new trial. We'd ask you to clarify that his hands weren't tied by this court's cases and that he's free to order the new trial that he believes justice requires.
Thank you, Mr. Nyman. All right. Thank you all very much for your arguments today. Given the court a lot of food for thought. We set these cases when we've got concerns, which is why you get a lot of questions, but we appreciate your diligence and the good briefing, and we'll take this under submission. Thank you.
All rise. Court is adjourned.